Attorney Peter Harbach from Hooper Law Office, and this is Attorney Sarah Kahns, and we're here to talk to you today about maintaining independence, which is our July theme. Today we're talking in context specifically about healthcare decisions. So it's one of those incredibly important, but not all that talked about aspects of estate planning. If something happens to me, what in the world is going to happen to my decisions? So we have a number of materials. If you signed up, the primary thing that we're giving out this week is a document organizer. And the reason for a document organizer is that you might have world's greatest estate plan. You got people who have the right powers and the right provisions in the plan. But if they have no idea where the heck your stuff is, how successful can they possibly be in becoming a good agent? Just because they're your power of attorney and they're the right person for the job and you gave them all the right powers, doesn't mean they have any idea where you're doing your banking or where your burial plot is, or who your investment advisor is, or who to contact for the auto insurance, or just anything. And so the document organizer is intended to give you a starting point to look at. All right, these are the things that are important for my situation, and here is where you can find them. And thanks, agent, for helping me out. That's our handout for today. I should also mention that if you have questions while we're talking here, please feel free and enter a message into the chat box if you're on Zoom. I believe we also have somebody monitoring on Facebook Live. We will reserve a little time at the end if anybody has questions about today's topic. And I guess the last thing is a little plug for next week. Next Wednesday on the 22nd, we're going to have the next in this series on independence. So hopefully you can join that one as well. All right, so healthcare decisions. How's that work?
Well, when I talk to my clients about healthcare decisions and how you want to make sure that you're prepared to have somebody in place to communicate your healthcare decisions, there's really a focus on 3 documents. And it's not only empowering people, but also making sure there's access to information and communicating your wishes. So there's sort of 3 different focuses on what you need to make sure that you're doing for preparation. The first document we're going to talk about is a medical power of attorney. A medical power of attorney is simply a document where you're naming a person to act as your agent and then giving them a variety of powers and authorities in order for them to be able to step into that role as agent and communicate your decisions. Now, I say communicate your decisions because that's really what you want your agents to feel like, that they're not making decisions for you. They are just communicating your decisions to a doctor or to a hospital on your behalf. It's much more likely that your agents are going to feel like they're doing a good job at being in this role if you've had conversations with them about what it is that you want or don't want concerning your medical care. But your medical power of attorney document is the actual document that authorizes somebody other than you to communicate those decisions to a doctor or to somebody at a hospital. Now, you want to make sure that you're paying attention to how old some of these documents get, because laws do change over time. Probably one of the most important laws that's changed with regard to medical decisions has to do with HIPAA. HIPAA is a law that went into effect back in 2003. It dramatically impacted access to information when it comes to people other than the individual themselves. So HIPAA essentially protects health information and prevents it from being communicated to anybody other than the person themselves, unless there is prior written authorization for the medical facility or for the doctor to be able to do so. And this applies to everybody. The law generally kind of assumes that people don't want your information to be provided to other people, including family members. So the hospitals and doctors' offices, medical facilities, they need to make sure that there is something in writing that authorizes them to have conversations with people. So if your healthcare power of attorney document is older than 2003, or if it just doesn't say anything in there about HIPAA or about access to information, empowering your agent to have conversations and an ability to look at records or talk to insurance companies, you're really going to have a hard time getting a good assistance from your agent, because they're going to be sort of hamstringed a little bit. They're going to have an arm tied behind their backs. So you want to make sure that you're paying attention to how old your documents get. Healthcare power of attorney, you want to make sure that as the laws change around it, that you're reviewing your documents on a regular basis to make sure it still works the way that you're expecting it to. It's good to have a separate HIPAA authorization as well. Your medical power of attorney tends to authorize an agent and give them the ability to access information. And although you might have backups listed in your power of attorney document, it doesn't automatically mean that all of those people have access to information all at the same time. So if you'd like your family to be able to call and find out what's going on, regardless whether or not they are your currently acting agent, HIPAA authorizations allow other family members, friends, other people that are important to you that you want to be able to access information or call and get updates to be able to do so. So a HIPAA authorization separate from your medical power of attorney can really help to make sure that all of the people that may be involved in decision making, a lot of family members, or families do decision making as a group. They have one spokesperson that can actually communicate decisions, but they tend to talk to each other when making especially large decisions. So having a separate HIPAA authorization really enables them to get good information when discussing major decisions. So there's one other document, living will, that expresses more your thoughts and opinions on your medical situation, as opposed to authorizing anything or empowering anything. So there tends to be a lot of confusion about a living will, especially when it comes to a living will versus a DNR order.
Mm-hmm. Yeah, a living will is your declaration of physicians regarding end of life care, sort of what you do or don't want. A lot of people, when I'm running through their wishes, they maybe not real comfortable with the conversation, so just sort of jokingly say, pull the plug. that's my wishes. And that's basically the type of thing that you're communicating in a declaration of physicians, or which again is a synonym for that is a living will. A DNR order is completely different. A DNR order is the do not resuscitate order, which is a physician's order to, for instance, not try and restart somebody's heart if their heart were to stop. And generally speaking, that's going to be a very thought out decision with your doctor. And you'd be wearing a bracelet if that were the case, if you had a do not resuscitate order, because if paramedics or anybody came and saw you had collapsed, they're not going to take any chances about, well, does this person have a DNR order? We're not sure. That's where, if you're expecting to not be resuscitated, well, you'd be wearing that bracelet, because that's a decision on the paramedics' part where they want clarity, because they can't take it back. There's no fixing mistakes on that one. So if your intention is, I don't want to be resuscitated if my heart stops, which normally is going to be people who maybe can't return to a decent quality of life because of some kind of significant medical condition, or maybe just older age, where they're saying, if I wouldn't want to go through the sort of the trauma of having my heart restarted because I have cancer, or I'm 95, so what's the point? Those are things I've heard from clients before. So again, that's where you'd wear the bracelet, where you're saying, hey, don't even try to bring me back to a quality of life. A living will, on the other hand, is just saying, in these different scenarios, this is what I do or don't want. So maybe I'm 18 years old and I'm just trying to make it clear that, boy, if I was in a coma because of a car accident, and the doctors are saying, boy, it is very improbable this person could ever come out of this coma, and maybe I don't want feeding tubes and things maintaining me and keeping me alive in a permanent or persistent vegetative state. Or maybe I do. And so the living will is an opportunity to communicate those wishes as sort of a clarification point to your healthcare power of attorney, but also to doctors as a backup so that they know what you do or don't want if there isn't a healthcare power of attorney that's available.
There's these three documents, the combination of them really positions you well to make sure that you have decided who it is that you feel comfortable stepping in to communicate decisions on your behalf, who it is you would like to have access to information, and what it is you want to say about end-of-life decisions. You don't want to rely on your living will entirely to communicate your decisions. You want to make sure that you've actually had conversations with your loved ones. They'll feel better about what it is that they're doing, the decisions that they're communicating, if they're recalling a conversation that they've had with you, and it's really your voice in their head saying, this is what I wanted, this is not what I wanted concerning my medical care. And you're not just relying on this piece of paper to communicate everything that you're thinking about medical care. So please make sure that you're talking to all the people that you're potentially naming, especially in a medical power of attorney. You may have signed various documents at different medical facilities, so you want to make sure that you are aware of what you've signed and where you filed different things, so that you can make sure things don't become inconsistent from one place to another.
Yeah, one of the most common problems that I run into anytime I do an estate plan with one of my clients, I always say, hey, every few years, I want to get back together with you and sort of assess the situation. You tell me how the family is doing and what's been going on in your life and your finances and your health. I'll tell you what's been going on in the law, and we'll see if this thing is still going to operate correctly. And one of the most common issues I run into is somebody has done their healthcare forms, the powers of attorney for finances and healthcare, living will, HIPAA authorization, and then maybe had a health event or was told by the doctor or hospital, hey, you're going in for surgery, you got to sign all these, this stack of forms here. And they might be a little out of it at the time, or maybe they're just, hey, this is a ton of paperwork. I'm not going to read all 80 pages of this stuff. I'm just going to start filling things out and signing, and not realizing that, oh, geez, one of the things that this nurse stuck in front of me was a healthcare power of attorney. That's this hospital form that I'm supposed to check some boxes on and fill out, but not thinking about the fact that, boy, I already did one of those with my attorney that was thought out and what I specifically wanted, and is written more from a patient perspective and not maybe from the medical provider's perspective. And so some people have inadvertently undone their healthcare powers of attorney because they're signing boilerplate forms in hospitals, not realizing that they already have a very complete form done with their attorney. And so that explanation leads us to one of the questions that we just got a couple of minutes ago, which is, if we receive a healthcare power of attorney, or excuse me, if we've executed a healthcare power of attorney, where do we keep it? Well, the answer to that one is, once you've done one with your attorney's office, you want to put that on file, all of your healthcare documents on file with your primary care physician's office. Because then it's at least within their network. So if you're at, say, Theta Care, if you've gotten it in with your primary care physician, well, then it's in the Theta Care system. So if you're in any of their institutions or getting care at any of their facilities, well, then they've got record of your healthcare power of attorney.
Possibly. I will warn you that
it's imperfect.
It's not, you can't rely on it. I've had clients where they're, despite the fact that they're within the same network, that certain doctors don't have access to certain aspects of things. So you want to make sure, if you want them to be accessible by certain providers, even if they're in the same network, that you put them on file with everybody.
But getting it on there is always going to be better than not bothering, because you think it might be imperfect. I mean, get it into these people so that it's in your medical record. Because one of the statutes actually says that if you provide a healthcare power of attorney to a medical provider, they are required to scan it and put it into your medical file. So make sure that you do that so that you don't inadvertently end up undoing all of your healthcare planning by signing a bunch of forms that were not created, thoughtfully by you and your attorney, because you can get better results when you are in a position where you're spending that time and working through that with the attorney than you can with the boilerplate form. For instance, one of the things that I generally encourage people to put into a healthcare power of attorney is a legal ability for the healthcare agent to express an intention for the person to return home if they go into a nursing home. Well, why does that sound important? Well, if you're concerned about long-term care expenses and you transition into a care facility, your agent being able to express an intention for you to return home can actually prevent a lien from getting put on your home if you're getting assistance in paying for that care. Well, a hospital form is not going to have those terms in there that provide that kind of sort of extra planning for the patient, because from the hospital's perspective, they're not thinking about, well, what if this person maybe transitions into a long-term care facility? How do we make sure that maybe we can protect some of their funds? I mean, that's just not the perspective they're coming from. So that's just an example of one of the types of things that can be very beneficial to have in that healthcare power of attorney, and that you don't want to inadvertently undo.
I mean, the medical providers, they are doing the best they can to try to help families avoid having to do something like guardianship. So they want to make sure that there's something in place that can help the family do that. But their role is not to explain options, explain what powers and authorities you have available to you. They're just trying to do something that's really basic that can help a family in an emergency situation. So relying on those long term might not be the best fit for your circumstances, which is why working through it with somebody who's looking at it from your perspective can be very beneficial to making sure that it's what you want or what it is your intentions are that's driving what it is that you're including or the people that you're empowering in the different positions that you are. The HIPAA authorization side of it is also something that I've seen some amount of inconsistency. Just because you have signed them with one doctor doesn't mean that they go everywhere. And usually when you're signing them at one particular doctor's office or medical facility, it's for that doctor, and it's usually for that doctor to bill your insurance company. They will sometimes have blanks that you can use to say, you can talk to my spouse or you can talk to these people listed here. But if you are then referred to a specialist or you're going to a different doctor, sometimes even within that same clinic, that HIPAA authorization doesn't just automatically then go with you. So it's also not something that your family has control over, that they can then present at the medical facility to say, I need to know what's going on. I'm authorized under HIPAA authorization to receive this information. So I get to receive this. You need to tell me what's going on. So it's something that the doctors have that they're using. You want to make sure that you have one that you're providing to the family that they can present at a medical facility, ideally at any medical facility, where they can get updates and information about what's going on. And it's not just for there's usually in these, in our education sessions, there's a lot of focus on our clients having these in place so their kids can have access to information. But you also have to remember, any child that is at 18 and over, you don't have access to their information either. So as soon as that child turns 18, there's an assumption that that child does not want their information shared with anybody, including a parent. So
and a legal prohibition.
Yes. So if there's something that happens, a car accident, for example, and the child is not conscious, and you're trying to find out what's going on, what the status of your child is, the medical facility can't give out that information. They might not even be able to confirm whether or not the child is there. And that can be incredibly frustrating in a situation where you're trying to find out just the basic status of what has happened. So having a HIPAA authorization that you control and can present at any medical facility can mean a completely different experience in any kind of emergency. You don't have to wait for that child to gain consciousness again. You don't have to go through any sort of court experiences or get like an emergency hearing for something in order to gain access to just basic information, because you have one simple document that you can use to do that. I mean, the difference is extreme, and it's a pretty simple thing that people can have.
So how does this all help maintain independence? Well, this is your opportunity, if you take it while you still have capacity, to lay out, well, how is this stuff going to work for me and my family? Who is it that I would want to get this information to? And or avoid having the information go to. And so the people you want to make sure can get medical information, you'd have them on the HIPAA form. It's your opportunity to lay out, okay, who is it I trust the most to make healthcare decisions? And are they in a good position to help me? You know, I mean, you might have a doctor's son, but if he lives in Alaska and has 6 kids of his own, maybe he's not the best person to be picking to try and monitor and help your health situation, because he's, you know, a few thousand miles away and has plenty on his plate already. So maybe he's not going to be able to do a great job in figuring out whether or not the nursing home is a good fit for you. But it's your opportunity to say, well, this is who I trust. And so I'm going to empower them to make these decisions on my behalf, so that my family's not going to be in a position where the court is going to determine who my decision maker ought to be. I'm taking the opportunity instead to make that choice myself, and then give them the authorities that I want them to have. So that if I perhaps want to be able to donate organs, if I was in a permanent vegetative state, that I say in my healthcare power of attorney, yeah, I give my agent the ability to consent to anatomical gifts, so that I know that my intentions are capable of being followed and carried out. It's my opportunity to say, hey, I want to make sure that, if I had dementia or Alzheimer's, what I do or don't want in terms of care being provided to me. If I can't express myself, or what are some of my priorities in care? Is it maintaining independence and providing healthcare at home, or am I okay with transitioning into a care facility? So this is how you're able to express and make legal what your desires are. And also, everyone should know that a healthcare power of attorney, just like a financial power of attorney, is allowed to be written either in an immediately effective capacity or in a springing capacity. Springing means there needs to be a declaration of incapacity. The most common standard is by 2 physicians or a physician and a psychiatrist. But the law actually just changed to open up the scope to I believe nurse practitioners as well in making those determinations. But that requires that declaration, and then you lose the authority to make these decisions, somebody else gains them. Immediately effective, you can say, well, this person right now has the authority to make healthcare decisions, but they can't overrule me. And so that actually might help you maintain some independence, because your agent never has a reason to get you declared incapacitated, because they can help. They are a current agent. They can get information. They can help you make decisions without saying, well, how bad do I wait for dad to get before we haul him to the doctor, get him declared incapacitated, because I'm not able to do anything in the meantime. And you don't have any kind of help then. So maybe it's in your best interest to get declared incapacitated, even if you don't want to be, because you don't want to lose all your decision-making authority. So, a little bit of effort proactively ahead of time while you still have capacity goes a really long way towards making sure you have the right system in place for you, that you're avoiding the court system, that you have people you trust in these roles, and that they have the different powers and rights to information that they're going to need in order to be a good, successful agent on your behalf. So, there's just no substitute for a little bit of time and effort on the front end to save a whole lot of time, effort, and in a lot of cases, money after the fact.
Mm-hmm.
So that's what we would encourage everybody to take a look at. Get on the ball on that one while you still can. I don't know about you, but I know I don't have my disability on my calendar, when I'm going to get in that car accident, or when I'm going to be struck with, some kind of, bad medical issue, or frankly, even, coronavirus. We've got, 3 million people in America have contracted coronavirus, and, some of them end up being fine or have mild to no symptoms, and others, regardless of age, are susceptible and have had very bad, health ramifications from the coronavirus. Well, I bet you a lot of the 20 and 30 and even 40-year-olds who've contracted it probably don't have healthcare powers of attorney in place. And that's a big problem. So a little bit of effort can save a lot of heartache on your family and friends if you just take the time to do it now.
I've had a few different instances where I've done entire family planning, where we do, originally I have clients that come in, they have adult children who are maybe between the ages of like 18 and like 40. And rather than just it being a focus entirely on the parents, that is the centerpiece of their planning, but they also do basic disability planning for each of their children, because they want to make sure that if there's an emergency, they're, especially the ones that are not married, they're still looking to mom and dad to step in if they're, have a health issue, or if they're just unavailable for a period of time. Maybe they have an educational opportunity and it requires some travel. I mean, nobody's traveling right now, but it may be in the future. So making sure that it's not just you, it's also all the people in your family. I've done that a number of times, and it has absolutely come into use for the families that I've done that for. And it's really made a big difference on how the family's been able to deal with emergency situations. With the number of people we have just in quarantine, it makes people unavailable for certain things like signing documents. So making sure that you have people that can act for you in different ways or have the ability to access information on your behalf can make a big difference on quality of life and independence.
Yeah, absolutely. All right, so I think we're out of time. I guess we already addressed the questions. So unless any other pop up right now, which I'm not seeing, I guess we're good to go. So our next class is going to be July 22nd at noon again. So Wednesday, July 22nd. Please register on Zoom if you're anticipating wanting to either ask questions or get the materials. And I hope everybody found this to be a good use of your time. If there's anything that we talked about that you find useful or that you need to pursue with your family about your own personal circumstances, feel free to reach out to our office. We offer complimentary initial consultations where we sit down and go through an individual's personal circumstances and give recommendations about what we think is going to be best for their estate plan. And I guess last note is that if you go to estateplanninglive.com, that's where we have these various webinars set for registration. So did I leave anything out?
I actually thought it was estateplanninglive.net. So hopefully you can always go to our website as well, and that will direct you to the correct location to register. Hopefully you can join us next week at noon, and we'll be addressing maintaining independence while staying in your home. So there's going to be a focus on what you want to make sure that you're doing to receive care where you want to, especially if you are receiving care at home.
All right. Sounds good. So everybody take care, stay safe, and hope to see you next week.
Thank you.